Hello, everybody. This is just amazing. So glad to see such a great group of jurists on. I'm going to wait one more minute before we get started. And then we'll do introductions and so one more minute.
I was looking for my pamphlet, which I read, but now my desk is a nonstop disaster area and it's eaten the pamphlet. So
That happens. Well, welcome everybody. Thank you for joining us. My name is Amy Lukes, and I am the Director of AOT Implementation here at Treatment Advocacy Center. We will do introductions after I have a couple announcements. First of all, I want to welcome a couple of newer staff members for the implementation team. The first is Shanti. Shanti, you want to say hello and share your role with AOT?
Sure. Hi, everyone.
I guess I might have to introduce myself.
Oh, sorry. My name is Shanti. I've been with Treatment Advocacy Center for about 1.5 years, but just joined this team. I'm the research and evaluation specialist, and I'm excited to meet you all.
We're really excited to have Shanti on board to, she's going to be focusing on data collection, setting up some infrastructure for data collection for AOT courts, and also program evaluation. The second person I want to introduce is Jared Wyma Bradley. He's say hello and
Hi. Thanks, Amy. Hi, everybody. I'm Jared. I'm coming from the inpatient side. I was working in one of the state psychiatric facilities in Virginia. And so I'm now here as the senior AOT advisor, and I will be working on some training materials and hopefully building out some programming in Virginia eventually.
yes. The final announcement is regarding Betsy Johnson. Betsy is stepping back from her role as AOT implementation queen. In June, she has been instrumental in taking Ohio from a handful of AOT programs to 34 across the state in jurisdictions large and small. But she is thinking about retirement, and she will be doing contract work for the implementation team on special projects, but probably won't be attending regular meetings. So Betsy, you want to say a few words?
Good afternoon, everybody. It's been a pleasure working with all of you. I see a lot of my friends from Ohio, so I'm glad you could be here with us today. I'll still be around, so don't hesitate to reach out to me. This may not be as present as I have been in the past, so good to see you.
Betsy and I are currently in Anaheim at the Rise 24 conference. And this afternoon, we're presenting on dismiss upon civil commitment with AOT. We're looking forward to it. We do this afternoon, so we'll let you all know how it goes and how the reception is later. But now we'll go around the room. Magistrate Kitzler.
Hello. I am in Richland County, Ohio. I am the magistrate. I have been involved in our AOT program since its beginning. We've been doing it since 2018, so we're starting to feel like we know sort of how to do this, but we're tweaking our program all the time. Right now, Ohio has just started sort of talking about doing what we call SB2 cases, which is coming to AOT out of a criminal case. We haven't seen as much activity in our county on that as we thought we would, but I think over time we will. That's about the only new thing that we're trying to figure out these days.
Thank you, Judge D'Antonio.
Hi, how are y'all? My name is Mark D'Antonio. I'm the Muskogee County Probate Court Judge in beautiful Columbus, Georgia, which is now adjacent to Fort Moore for some of y'all that aren't familiar with this area. I haven't been calling it AOT, but I've been signing involuntary outpatient orders for at least 14 years. And how I handled them, well, I'm going to give major props to the Treatment Advocacy Center. I've always wanted to have more training on best practices, and some of the things I probably did 14 years ago now make me shudder. But the more I'm doing this, the more I'm really learning how to do things. I had actually I'm doing hearings on Thursdays. Last Thursday, using the LEAP way of talking to an individual, and this might send shudders down y'all's spines too. I talked an individual into taking his shot of Invega Sustenna in my conference room.
You go, Judge.
Well, and in exchange, I bought him lunch the next day, and we ate sushi for like 2 hours.
Holy moly! Okay,
But it was. I'm jokingly telling how I'm trying to sell LEAP and Dr. Amador on folks is it's almost like Jedi mind tricks. Well, but I mean the whole part about the agreement and really when we were in terms of the partnering, had he not taken his shot, they were pretty much planning to evict him, and he likes his current apartment, and we were able to talk about that part of it. And then he was still close to the edge, and I was like, well, if you do this for me, how about we just have lunch tomorrow? And that pushed him over the edge. Of course, the part that y'all might be concerned about is ACT team folks coming to court with Invega Sustenna shots.
I wish.
Well, I mean, as I said, it worked. The sheriffs that normally handle criminal matters were not exactly comfortable with some of my conduct in terms of looking at it from a safety point of view. But again, it seemed to, so I'm completely have drank the Kool-Aid, as it were, if we've seen more bad analogies.
Well, thank you. So some of you I don't know. So I'm not certain if you are a judge, a magistrate, or whatever. So I'm just going to call you a judge if I don't know, but feel free to correct me. Judge Brown?
Thank you. It's Magistrate Brown. I am a probate juvenile court magistrate here in Claremont County, which is the county directly east of Cincinnati here in Ohio, if you're familiar with that area. I've been doing AOTs since 2020. We started our AOT program here in Claremont County in 2019 after attending a conference for the state in Columbus where we got information about the program. So we're still working out some of the bugs, as you will, trying to make sure that we are being as effective as we can with our mental health patients. We have experienced here recently an increase of referrals from our municipal court, especially for individuals who have been found to be not competent for trial. So this is a new area that we're kind of branching out to. Primarily, we get our clients from the local hospital who is just across the street from where we are. So this is definitely a very timely topic as it relates to our needs here in Claremont County.
All right, Judge Waller.
Dan Waller, I'm a judge in Portland, Oregon. And a number of years ago, I went to Ohio to look at your AOT projects with a delegation. I handle a consolidated competency docket and our mental health court. And we are under federal court management of our admission to the state hospital. So we are desperate to look at options to deflect people from the criminal justice system who are appropriately not needing to be in the criminal justice system. In AOT, we have a statute, but it is a statute that was passed a number of years ago, and it really doesn't have any leverage. So it's the oxymoron of a voluntary court docket, which we don't think anyone will actually want to participate in all on their own. So we are looking for how we change. We've just finished under the Chief Justice's authority an 18-month overlook of our civil commitment statute and AOT, looking towards legislative changes in the next session. So I'm here to learn more, but I appreciate all the work that Ohio has done and that the Treatment Advocacy Center has done. Thank you.
Judge Phelps.
Good afternoon, everybody. I'm Tom Phelps. I'm a senior judge in Fort Wayne, Indiana, working with the education folks at the Indiana Office of Court Services, educating judges. Trial court judge for 31 years. I'm trying to generate some AOT interest in Indiana, frankly, and we're having some difficulty in fighting some uphill battles doing that. I'm happy to hear from the Ohio folks that they have had more success, and being so close, I can have some neighbors to look to. I'm new to the AOT world in the sense that a NAMI member actually approached me about a year and a half ago, asked if I've ever heard of AOT and why isn't Indiana doing something about it. Set me on a mission to see what I can do. So I'm just here to get some information together. We have one judge in one of our smaller counties in the northwest part of the state, Judge Fish, who is doing some AOT work. But besides him, I think we're pretty much behind the times and need to catch up. So I may be reaching out to some folks for some ideas, but just trying to generate some buzz and interest in Indiana and getting this project moving forward. Appreciate the opportunity to participate. Thank you.
Well, thank you for joining us, Judge Abriel.
Hi, good afternoon. My name's Courtney Abriel, and I'm actually a newly appointed judge. I take my oath tomorrow, but I have been in the public defender's office. We do have an AOT court here, and I have participated in that. We have a mental health court. We also do conservatorship. So I have had experience in a number of these areas. So I'm here to listen as I move forward into whatever my new assignment may be. So thanks for having me.
That's excellent. Where are you located?
I'm in Nevada County, California, just outside of Sacramento.
Yes. Taking over Judge
Sloven?
No, Betsy.
Anderson?
Yes.
Judge Anderson was instrumental in some of these things.
Nevada County
yes,
judge.
Absolutely.
Judge Green.
Good afternoon, everybody. I am the chief magistrate with the Franklin County Probate Court in Ohio, where we have had an AOT program for several years. I got primary responsibility over this program in the past few months. And although we have been doing these and they have been going well, we are looking to expand our program. So we're going to be visiting some of the other counties in Ohio that have a more robust system, and hopefully in the next several months be able to start offering expanded services.
So glad to hear that. That's great news. Magistrate Specia.
Hi, I'm the Director of Psychiatric Services for the Cobb County Probate Court. I'm in charge of the AOT program and our Guardian Partners program. For a large county, we don't have very many AOT participants. We're kind of hamstrung by the multiple providers that we have in the county, and they're not all always very cooperative with people we're putting on AOT. It's difficult to get continued commitments, letters. it's difficult to get just cooperation on a whole. So we've had more success lately, and we're getting our special magistrates to put a little bit more effort into, seeing what individuals may be good candidates for AOT. We don't put everyone on commitment on AOT. We try to put people who would be best served by AOT. So, I mean, we're moving forward and trying to get more people, and we're trying to get those people who we could help, because it doesn't do any good, I don't believe, put someone on AOT who doesn't want to be on AOT, who won't be housed, who won't meet with their provider, who won't take their shots. It turns into just a big waste of time. So we'd rather deal with those people who have just a little bit of interest and a little bit of insight.
Thank you. Judge Jones?
Hi, I'm Anthony Jones. I'm a district court judge in Jefferson County, Kentucky. I am just sitting in today for Judge Stephanie Burke, who has a corresponding meeting going on right now. So I really don't know much about it. I'm going to be like a fly on the wall, just taking notes and trying to bring back stuff. She has been instrumental in spearheading the program in Kentucky, getting laws signed and always working on getting funding for it. So I'm just sitting here trying to bring back stuff to her so that she can keep on doing what she's doing.
Excellent. Well, thank you for joining. Judge Wiles.
Hi, I'm Judge Letitia Wiles here in Wayne County, Ohio. I have juvenile and probate court jurisdiction, and we have had a AOT program for a couple of years, but not really a lot of participants. So we are working on growing our program. Thank you.
Judge Miller. Judge Miller? Nancy Miller? No? Before I get to Judge Strelitz, I overlooked introducing Brooke.
That's okay, Amy. Hey, everybody. I'm Brooke Gentry. I'm the AOT implementation coordinator on the team. You might recognize my name from emails. It's great to be here, and it's always so wonderful to have such a good group for this chat, and to see some new judges on the screen. So.
And Brooke is the glue that holds the implementation team together for sure. So sorry about that. And now, Judge Strelitz.
I'm Joseph Strelitz. I'm the associate judge for El Paso County Statutory Probate Court #1 in El Paso, Texas. And I get to hear the AOT cases. Originally, it was because I was the low person on the totem pole. And now I've never been more thankful to be the low person on the totem pole, because this is a court that I get a great deal of enjoyment out of. Not everything is a success, but when you have a success story, it just, makes you see the whole world in a new light. We have had AOT since 2020. We're in our 4th year, and I feel like I still have a lot to learn about AOT. We originally started out with a Cadillac. We had a psychiatrist, a therapist, 3 caseworkers, licensed clinical drug counselor, and a secretary to help our primary caseworker, who kind of runs the program out of our local mental health authority, which is called Emergent Health Network here in El Paso, Texas. And when I started the program, I thought, man, this is great. We got all kinds of help, and all we need is participants. And as the number of participants grew, our grant ran out, and I was told that we needed to have positive cash flow. And that was news to me. And having positive cash flow in this world, when you're dealing with mental health issues, is very difficult because insurance doesn't always cover. Not everybody qualifies for Medicaid. When we get them, our caseworkers try to qualify them for Medicaid, and it takes a while. Sometimes by the time we pass a participant off to a less intensive program, they've qualified for Medicaid, and that program's caseworkers can bill Medicaid, and we don't get any points for that. So as time has gone on, our Cadillac, because of a lack of funding, has turned into a well-functioning VW bug. I think it's a convertible, so it runs well, it works well, but now we're down to 2 caseworkers, and we have interns as therapists, although I'm told we're getting ready to hire a new therapist. We were full when we had 3 caseworkers, and now we're even more full with 2 caseworkers, because I think the maximum amount of participants a caseworker can handle is maybe 15, especially if you're trying to get your caseworker to meet with each participant twice a week for an hour and really help them out. So our 2 caseworkers have been a wee bit overburdened. When we were starting out, we were looking for ways to increase our census. And one of the things that we decided to try was to open up our AOT program to criminal misdemeanor cases. And what we found, which was really disconcerting, was that when people were in jail, even though our local mental health authority has a treatment program that impacts the jail, they weren't getting the treatment that they needed. So when a criminal court referred someone out of the jail to us, they weren't ready. They needed to go into a mental health hospital for some stabilization before they could come to our program and have our program be effective for them. And I couldn't quite figure out why that situation was a problem, because we had EHN in the jail providing services. There was a psychiatrist there that was treating some of the folks that were in jail. They were getting their medication. And what I've learned is that jail is just really not conducive to treating someone with a mental health issue. One of the more fascinating things that I learned was that when you have a mental health patient who's getting treatment in jail, some of the other prisoners that live in the same cell or in the same area think that maybe they need to start taking the medication too. And so what happens is the mental health, the prisoner with the mental health issue goes and gets the medication or is given the medication. And what you find is they cheek it, or they, hide it in their hand, or they do something, because when they get back to their cell, there's a person that's bigger and meaner and tougher than they are who wants their medication and takes it from them and takes it, which was astounding to me. I don't know why, because, being in jail is being in a tough place, but I just couldn't imagine that certain prisoners either had the insight or, I don't know, the foolishness to think that they needed to treat themselves with the medication that was being given to the individual with the mental illness. And I haven't had a chance. Right now we're having a new election for our county sheriff, and the county sheriff runs the jail. And what I've found is that while the present county sheriff does a pretty good job and tries to help out folks with mental health issues as much as he can, it's just not their number 1 priority. It's not their number 2 priority. It's not their number 10 priority. I mean, it's low on the totem pole. What I have advocated for, and what I'm going to continue advocating for when we get our new sheriff, is that they try to separate the mental health patients from general population. And I suspect that's probably much harder, much easier said than done. But I think it might help our mentally ill population in our local jail system to get better treatment. So we took.
All right, I'll send them.
All right, sounds good. Have a good weekend. Golf tonight? Get 'em straight.
We've been successful with folks that have criminal charges, really successful. We have found that when the participant completes the program, 9 months, we try to keep them for a year, minimum 9 months. We've had some people for as long as 2 years. We've had some people that don't want to leave after 2 years. They kind of turn it into a crutch. So you have to kind of wean them off. But what we have found is that the lawyer who is the ad litem that represents the participants, she monitors their case on the criminal side, and when they come up for a judge's conference or a status conference, she prepares a report and a packet about how well they've done in the program, what they've done in the program, who they've worked with in the program, and she sends it over to the district attorney, and typically these folks are represented by public defenders. And we have found that report is really helpful in getting charges dismissed. After the participant completes the program, oftentimes the case is dismissed. And what's been nice is that I think we've succeeded in making people in El Paso County very aware of the fact that we do have AOT and that we have successfully helped a number of individuals with criminal issues and mental health issues navigate the criminal system and graduate with a better life and more capability to understand that they're ill and they need to take their meds forever. And the judges on the criminal side like us. They know who we are. They wish they could refer more cases to us. And so we're always looking for money, and we scheme here and we scheme there, and we look at all the grants that come through. And right now there is the governor of the state of Texas he's always given a bunch of money that he can dole out to mental health courts. And the statute that enables him to do that did not have AOT as one of the courts that qualified for that money. And we've made a big push, and I think that we may get that law amended to allow AOT courts to get some of that funding, which is just going to be phenomenal. Because I don't know about the rest of you that have been doing AOT for a while, but what I found was we ran out of grant money and we weren't done using it yet. We needed more to continue our program because insurance doesn't cover, and so my latest scheme, after I read this pamphlet on AOT, my new scheme is to look and see how many people are sitting in jail on misdemeanors and simple assaults or simple felonies like burglary, theft, simple assaults, that we could take in lieu of being determined to be competent. We'll ask the courts to send them to us, and we'll help them. And ultimately, if they successfully complete the program, those cases will be dismissed. What we need to do that is another caseworker. So what I'm trying to do right now is have a study done that might indicate how much money we would save our county, because it's all about saving people money. If you want them to give you money, you got to show them that what you're doing is going to save money. I want to be able to show that being an AOT is cheaper for the county than housing these people in jail and sending them off to we have one state facility here in El Paso. We have one state facility and 2 private facilities. Private facilities don't accept folks with criminal issues. The state facility does. The state facility is being expanded to add 75 more forensic beds to try to help more folks that may not have the capacity to aid in their criminal defense gain that capacity. But right now, we're shipping people across the state to other institutions, and those institutions bill our county. So my hope is that I can get the county to give us the money for another caseworker, and we can take on some of these cases and help people achieve a better outcome. Anyway, I think I've probably gone far and wide from what you wanted me to talk about, Amy, and I'm just wondering if anybody else has any experiences or any ideas that they could throw out that I might be able to gain from. Yes, ma'am.
Just a quick question, Judge Strellis. You mentioned that they dismiss the charges after they complete the AOT program. Is there any consideration about dismissing the charges at the front end, maybe with the opportunity to refile if they don't complete the program?
We have not seen that at all. We've tried to pitch it. Of course, the public defender's all over it, and the DA is not so receptive. We're also getting ready to elect maybe a new DA. Our present district attorney might win re-election, but I think we're probably going to end up with a new one. Some places in the United States, if you're not a Republican, you don't get elected. Some places, if you're not a Democrat, you don't get elected. El Paso is a little, we lean Democrat heavily, and we're kind of a microcosm in the state of Texas, which leans Republican heavily. So whenever we lose a DA, which we just did, she stepped down. The governor always appoints someone that's a Republican, and then they run in El Paso and they lose. So I think we're going to get a new DA is what I'm saying, and maybe they'll be more receptive to that plan. I hope so, because I think it kind of relieves some pressure on the dockets of the criminal courts. And everything today that has to do with courts, in my opinion, is about statistics. How fast are you moving your cases? How many have you disposed of? That kind of thing. So we're going to make all kinds of pitches and see where we go. It's a nice way to do things, though.
It shouldn't be too hard to make the fiscal case for it, because there's no doubt that having people in the community is a lot cheaper than housing them in jail.
Yeah, absolutely. So, our county's under a little bit of a fiscal crunch this year. In previous years, we've done great. This year, for some reason, we're under a little bit of a fiscal crunch. So my impression is that if they can find a way to save money, they're going to try to keep that money and not utilize it for something new that might be more effective. But, we're just going to try to work around that and convince people otherwise.
What about others of you that are overseeing AOT dockets? How do you think about this? I know Magistrate Kitzler, you said that there's a few cases trickling in. I did put our handbook in the chat if you want to download, if you haven't seen it, but I'm just curious what others think, and is this something that you would like to try, or if you're doing, we'd love to hear about it. Especially what's working and what's not.
The hard thing for us to deal with has been, and I don't know any other way to put it, dealing with people that have a criminal mindset. And once they find out we can't put them in jail, they are not always willing to be cooperative. they're sometimes we're dealing with people, particularly long-term mental illness, that have been in the criminal system for years, and they've developed a certain way of thinking, and you know, everything's based on reward and punishment, and you know, so they're not sure how to behave in our setting, and we don't have a lot of experience dealing with that type of person either. So it's been a challenge on top of dealing with the judges in the other courts that are referring the cases. So it's been a slow trickle. We've got one person now that came out of a criminal case on an NGR, or not NGRI, incompetency to stand trial. And we had some bumps in the road, but she's finally starting to do well. But we almost lost her because she asked me one day point blank something about whether I could put her in jail. And I said, no, I can't put you in jail. But if you're not doing well, you know, in your mental health treatment and you're decompensating, we can do certain things. But putting you in jail is not one of the things that I'm authorized to do. And that sort of took the wind out of our sails for a minute. But then she had another hospitalization and decided we looked pretty good, and she's doing better now. But I would have predicted that we were going to lose her once she found out that there was no jail time possible for missing appointments and court appearances and such. So it's been slow going. We've had to kind of change our approach a little bit, but I feel good that we're off to a slow but sort of good start.
So just a comment there. While I love Ms. Johnson's suggestion that the case be dismissed at the outset, what I have found is that if the criminal court just refers you the case and hangs on to the case in chief, what you can tell that participant is, look, if you don't play by our rules, we're just going to send you back to the criminal court and you're going to end up back in jail, or, you know, what have you. We're offering you a method for getting out of the criminal system and staying out of jail, hopefully, you know, for the rest of your life if you follow the protocols and work the program. So one thing that's nice about working with the criminal courts here in El Paso is they'll hang on to the case. Or if you know, they let somebody out on probation, or no, not probation, it's not the but part of their bonding requirements. I'm not a criminal. I know enough criminal law to probably get myself put in jail. One of the requirements for like getting out on a personal recognizance bond is you got to go to AOT. And if they don't show, we give a negative report, and that creates problems for them back on the criminal side. So maybe that's something to look at as well.
Can I ask a question about that? Again, I'm a guy who doesn't know any of this stuff, just standing in. But if the corresponding criminal court, so there's a simultaneous criminal case is going on, do you know what's the suggested amount of time that they review those cases in conjunction with the AOT proceeding?
I think that what they've done is maybe a status conference every 6 months.
Okay.
And that seems to have been effective. You know, early on, we were taking people straight out of the mental health hospitals. And we had one guy who was an arsonist. And, you know, he was up on felony charges and he had a criminal record. And he worked his way through the program, and he's one of the greatest success stories we've ever had. And the district judge was so happy with his progress and how well he did. Those charges all got dismissed, and the prosecuting attorney was willing to do it. And we were ecstatic. And he's had one small relapse where he was feeling kind of depressed. And he went back into the hospital for maybe a week, and we've accepted him back into AOT, but his life was a disaster. He's doesn't miss a dose of medication. He's repaired his relationship with one of his sons, and is working on repairing a relationship with another son. He's healthy. He goes to the gym every day. He eats well. It's heartwarming. It's just a wonderful story to see how well he's done. And he's going to come back in for what I would call a tune-up. And then I think he's going to go right back out and be great again. So I think, when your criminal court looks at this case every 6 months, and initially your participant knows that criminal judge is keeping an eye on him, it's a motivator for a lot of those folks.
If you see somebody slipping in AOT that's starting to lose interest or starting not to feel like there can be a consequence, I guess, do you all is there the ability to notify the criminal courts to tighten up or to shorten the date or get it on a contempt motion?
Absolutely.
Quicker than that 6 month period?
Oh yeah, absolutely. So we have a liaison between AOT and the criminal courts who's just on it. She's on top of this every day, all day. And we just mention something to her, and she goes in and sees the judge from the criminal court, and something gets set up pretty quickly. And they get, that particular individual gets reined in, and the criminal judge has a talk with them, and I have a talk with them, and we've been pretty persuasive so far. We really haven't had anybody that we've just said, okay, we're done with you. We're sending you back to criminal court. Good luck. Which I think is, been really neat to see. Anyway, I hope I answered your question, Judge Jones.
Yes, thank you very much.
Magistrate Specia?
Yeah, we recently had an issue with our county mental health board a couple months ago, and just interested in everyone's take on this. I went to the judges probably about 6 months ago, and our court does a lot of force med hearings, and I asked the court if it would be okay that when we do a force med, that our force med order stays in full force and effect during the 90-day period of commitment. Because obviously when someone's discharged from the hospital, the commitment is ended and the force med's over too. So the court said yes. And I present that to the Adams board, and they're all in favor of it. So every time somebody had a force med, I put them outpatient commitment. And then when that tragedy happened in Maine, I got an email maybe a month after that, and they said, whoa, from now on, if a person isn't meeting with their provider, if they aren't, if we aren't getting a weekly report, if this, if that, we're going to just terminate their commitments. And I said, oh, because according to, and I don't know, obviously she's very intelligent. She's an attorney also. The chief medical officer for the board is that if there would be something would happen and they didn't know where this person was, that was an outpatient commitment, then she'd have all this liability and the board would have liability, and we can't have liability. And I'm thinking, okay. So then they terminated, I think, probably a dozen commitments. And that's very frustrating because the board has the ability to terminate commitments. And if the providers aren't doing what they want them to do, they'll terminate commitments. And so I had 10 people who I had to hammer, get your shot, or I'm going to send you back to the hospital if you decompensate. And it worked a couple of times, but then they took that away. So I don't know what the actual liability for the board is if something happens, because I'd be of the opinion that every time the mentally ill person goes off and has a rampage, someone's going to sue the Adams board or the county board for negligence somehow. And I think it's nonsense.
I agree wholeheartedly. And I think it seems to me that you're more at risk if you know that someone is mentally ill, they've been on a court order, and you just discontinue it. And I don't think the board can discontinue it. They can,
They can terminate it according to the code.
That's unfortunate, I think.
Yeah, I thought that a judge or magistrate had to
Not in Ohio.
discontinue it. That's news to me.
And we don't, we don't terminate, if someone has on AOT, we've had people on AOT for up to 4 years. And they did really well. And a couple of people, and there's been people that we had on AOT that needed to be on AOT, and we couldn't get a letter from the provider for continued commitment, or the board decided, oh, wait, they're good, they don't need this. And it's like, it's nonsense. So the frustration for me, no matter how well-meaning it is the county mental health board sometimes. So.
Yeah, it doesn't work like that here in Texas. And I'm wondering if maybe you need to talk to your local congressman and get them to try to amend that law in some form or fashion, because the only person who can terminate an AOT commitment is me. And I've never done that. So I think that's, hellaciously.
We've got the practical thing that if the mental health people won't treat, what can we do? If they have done a professional assessment of some kind and they determine this person no longer meets their criteria, we've always been at the mercy. It's just like that with initiating. You can't commit anybody in the first place if you don't have sufficient medical, psychological evidence. So, we're stuck with that all the way along. Sometimes we get cases where they file an affidavit, and before we can even have the initial hearing, they let them out. That doesn't happen as much anymore, but it used to happen a lot. And I used to think, well, wait a minute, I gave them a detention order. Doesn't that mean something? But the doc at the hospital let them go because they decided they were getting better and taking meds or whatever. But that isn't quite as frequent as it used to be. But there's always been this tension between the psych people and the legal people. And you just have to try to be creative and make that work. That's the best advice that I can give when it comes to that.
I don't have any problem with the hospitals or the doctors. My issues
the board letting you continue
with the board. And we have probably 8 major providers in this county, so it's really difficult sometimes, and there's a shortage of money like everybody has. So to get people to say, okay, I want to take this person and treat this person, we'll accept your AOT person, but wow, we really don't have time to do a weekly report to the board. How's this person doing? Because they don't have the manpower to see somebody every week. So, some of the requirements are a little difficult to adhere to, but I think at the end of the day, doing something is better than doing nothing.
Right.
Absolutely.
On the forced med issue, to have it apply for that 90-day period, just so you know, Magistrate Judge Brannon from Montgomery County is pursuing legislation in that regard. I don't think anything's been introduced yet, but as soon as it is, I can forward that off to you.
Thank you. I really need to get this call. I'm sorry.
The problem with the non-voluntary medication is not necessarily getting the paperwork, it's the actual logistics of administering the medication. That is the difficulties that we are running up against here. We can create a beautiful AOT program, but the actual physically administering the medication to the individual is extremely problematic because a lot of the medical providers, they need to do it in a safe manner for their own staff as well as the patient. So what is more important is some type of delivery device is going to allow for that medication to be administered to the patient in a safe manner when they don't want to take it. That's the beauty of the long-acting injectables, is because it minimizes the amount of time that they actually are administering the drug, but still just getting them to the point where they can put the needle into the appropriate place. That's what we're having difficulties with, as well as dealing with the dual diagnosis where substance abuse is preventing treatment of the mental health and the mental health is preventing treatment of the substance abuse. So that's kind of the big issues that we're struggling here with Claremont County, as well as criminal referrals who do not meet the criteria, but they are still found to be incompetent. So those are the three challenges that we kind of are working with here as we kind of expand our program in a sense to include more people to be part of it.
I can speak to the med thing, but before that, the other part is if you can't talk folks into dropping the charges up front, in Georgia, we have something called a dead docket. Basically, things are usually placed on a dead docket to toll a statute of limitations. And sometimes you can convince prosecutors to put it on the dead docket. And hey, you can always bring it back, but that seems to be a way of convincing some people that would be opposed to what we'd call a null pros. As to the forced med issue, that's what I've learned from folks, is that that's not what I should be doing, generally speaking, at all with folks that are in AOT. I can force med somebody, but that doesn't help build that rapport where they're going to want to continue to participate long term. Having said that, I had a very agonizing case I'm still beating myself up over because I'd seen this lady decomp so badly before, and we had reviews for 9 months where she was refusing to take her meds and was going to do it through, like, I don't know, some kind of organic thing. We worked out a protocol with one of our psych hospitals that has a 23-hour hold bed. And it also, and we have a way of enforcing an outpatient order is something I can order to apprehend a non-compliant individual for up to 48 hours in a psych facility. We had to go through another layer of protocols so that the doctors, even if I was ordering it, would be comfortable doing it based upon evidence about the use of a long-acting injectable in the community and things like that. I also will not do that unless I want specific expert findings that this person has so decompensated to the point that they no longer have the capacity to make informed consent. And I'm still not sure that I should be doing this at all, ever. But those are the ones I've done it once. I lost some sleep over it, but I did spend what that did accomplish is we have now a memorandum of understanding between the hospital, the State Department of Behavioral Health, Developmental Disabilities, our local providers, that in these situations, if we really, and we're going to jump through a lot of hoops before I'll ever go, and I'm not sure I'll ever go there again, to be honest with you. That's how much I've learned from you all. But if it comes to that, the thing I would think about is talking with your hospital about using the 23-hour hold bed that perhaps the state might even be putting some money into, and making sure that you all really work that out. I have a very elaborate order that I'd be happy to share with people, but I've been reluctant to share it with anyone because I don't want people doing this. There's my 2 cents on that.
when we say no forced meds, there are times when there are no other options. I, as a clinician, having witnessed the administration of forced meds, would never want to see that in the community. It has to be in a hospital setting or a secure setting, a crisis center. Because what we're talking about is sometimes 2, sometimes 3 people holding a person down while a nurse administers the injection. So this is not something that should be done in the community.
Yeah, in El Paso, they've often accused us of having lithium in our local water. And we're all pretty mellow, I think, for the most part. But I've never had to do forced meds in AOT. And my theory is that even though I never want to give up on anybody, if you're having to force them to take their meds in that manner, then they may not be appropriate for the program. What happens here?
Not true.
Yeah, well, I feel like there's that voluntary component. And, what I've learned is that AOT is much more successful when the participant wants it, when they want to participate, when they want to get better, when they're done with the frustrations of jail and mental health hospitals over and over and over again. That doesn't mean we give up on these other people, but.
Well, one of the things about that, I think there's a distinction between accountability courts where I do expect folks to have more insight, and perhaps some of my AOT individuals that will probably never have a lot of insight into their mental illness, but through spending a lot of time, I can sometimes, well, most of the time, convince folks to be compliant. I'm not going to rule out forced meds either, but and Amy, you made me feel a little bit better, because the thing I was going back and forth about was, should I have just let this person go and end up back on the streets, back in the jail, and she was in terrible shape before she got, and it took a real long time in an inpatient setting to stabilize her. Once she decomps, it's so hard to get that person back. And every time I see people decomp, their baseline might be a little bit less.
Exactly. And the other thing, at least, my clinical practice was in Ohio. There are 2 different standards for civil commitment and forced medication. Now, this is back in the 1900s, but someone had to lack capacity, and there was a greater burden of evidence for forced medication. Judge Waller, you were starting to say.
I started to say something and realized my volume might not be working. I'm glad it is. But I would be very interested in, because I think that, of course, we want people to want to participate, to want to engage. And I think that there are, at least I hope that there are tricks and tools on the aid and assist side, which I'd like to get AOT in place. I see that you cited Dr. Bloom's article about why our aid and assist rates have gotten so high, and the brochure that you sent out on dismissing upon civil commitment, is that from the behavioral health staff, when they're going in to talk to somebody, is this a good person for community restoration? The person says, I don't want to work with you. I don't want to take any medication. And that seems to be the end of the conversation. And then it is, well, they're not a good person in the community. And so I assume, and I've been asking, well, what are we doing in order to engage? Because I have found that when I then have the person in front of me and I begin talking with them, I can often get things to kind of turn around to the point where they are. So I'm interested in the active engagement tools that I know have to be out there as to how we get people to embracing the possibility of medication, of
participating in skills and not just having, and I think that part of it is philosophical. Criminal justice system is a system of mandates. I can order people to do things. Obviously, it's much easier if I can convince them that that it is a good thing for them to engage in what I'm ordering. It will be a lot simpler. But our behavioral health system seems to be premised more on this should be body autonomy. This should be what people want to do it, then that's great. But if they don't, then they can come back to us when they're ready and we'll help them. And how do we merge these two systems so that we can have an understanding of it's okay to actively engage and encourage engagement of individuals in order to get them to a point where they can comply with court orders without us having to use military means or send them to this. I have a comment there. What we do when we have someone who's refusing to take their medicine or an injection of a long-acting medication is we bring them in for a meeting. It's not a formal hearing. Most of the people that I meet with every Thursday afternoon, we just sit and chat about their situation and how they're doing. And I think the black robe effect has an effect when you're trying to convince them to take their medication. And so I bring them in, we sit them down, and I do my best to talk them into doing it. And then they go in to see the nurse practitioner, and 9 times out of 10, they agree and they get their injection. So I agree that I'm pretty good at it, encouraging and convincing people that's the right thing. I'm more concerned that the tension sometimes between the criminal justice system and the behavioral health system limits the availability of community participation, because if the behavioral health system is not using active engagement techniques and then coming and saying, not a good person for the community because they're saying that they don't want to, I quite frankly don't have the ability to do that kind of discussion with somebody to get, and I involuntarily or sign involuntary medication orders for people in the hospital. I understand that sometimes that's going to be necessary, but my biggest concern is that there is a tension between sometimes our two major systems, the justice system and behavioral health, in terms of how we operate and whether, and quite frankly, sometimes the behavioral health system, I think, doesn't, there's some degree of bias against people in the criminal justice system and don't want to work with them, too risky, concerns about liability, the other things that some of the other people here today have said. So I'm really interested in what are where to look for, how do we actively engage people so that we can get them diverted from the criminal justice system, because they are at the point of saying, yes, I will. We're in the process of, we decriminalized controlled substances, now we've recriminalized, and there's a deflection and diversion option, but it has to be, it's only going to work if people are being, there are some efforts at active engagement so that people will take those options. The numbers are going to be enormous, and it's not going to be possible for judges to participate in each of those discussions.
This is
a big question, Amy. Sorry.
No, this is why it is so important that AOT be practiced in a collaborative manner. You're absolutely right that the mental health system is not great at engagement and is really good at working with people who knock on their door and want to be there. But when it comes to our population, there is no choice. They have to do the engagement because these people are never going to knock on the door. And that is why we say the court order is not only an order for the individual with a mental illness, but it's also an order for the mental health system to provide those services. And
Amy, our programs, because oftentimes it's the behavioral health saying, we can't take this person. And then that's kind of the end of the discussion. Or programs in the community saying, we can't take this individual, we're not going to work with them. They're given the choice. So as a judge, I can't order somebody, I can say this person, this is what they need, I'm ordering them into treatment. But if nobody will take them, then I'm kind of stuck. And that's the part that I'm interested in shifting for a better understanding of the mandates of the criminal justice system. How do we help encourage embracing that concept by the behavioral health system? Because that's the piece that I think is really necessary in order for all of this to work.
Give them funding directly earmarked towards having to engage with the folks, although I'm doing them on civil commitments, but that, like, hey, you already accepted this grant money. To be honest with you, is a way. And I usually, as I said, I again go back to what Amy's saying. Everything is collaborative. If I can, the more folks I can invite, and I will let anyone that subject to the individual consenting. I will let anyone that wants to watch my hearings, and I'm using that as a way of helping. Well, first of all, understand that I'm not just ordering people to be held down and against their will, and to have a better understanding of how this is. And the more folks that actually watch what I'm doing, the more people, including a lot of the very skeptical behavioral health side, who are just, the whole idea that I was putting out a court order was really repulsive to them initially. But when they see that this is not how it's really working in a collaborative way, and how I'm really more interested in talking with folks and treating them as individuals, the more I get buy-in. It takes time, and there's some folks that you're never going to, but if they have if there's grant funding, or if there's funding from our Department of Behavioral Health that is specifically earmarked for them to work with me, that usually helps them work with me. Does that answer your question?
Accountability.
Yeah, I think that's a huge point, is that, there is a structural reason why the mental health system doesn't do engagement. And that is, they don't get paid to do it. And if there is some mechanism to pay them, which is why we suggest that any money that is any grant money, whether it's a federal grant or a state grant, be used to subsidize those non-billable services.
Are there Medicaid waivers that anyone has gotten for this engagement piece?
Well, so that's an interesting question. There are two ways to pay for engagement through Medicaid. One is with ACT, assertive community treatment. That is, they're required to do outreach for that population and are paid to do it. It's becoming also part of CCBHCs, and I'm not sure if Oregon is moving in that direction, but CCBHCs also have money in them for engagement services.
A study group we have a couple demonstration sites to increase our CCBHCs. I felt that there's a need to move them in the direction of, as some states have, of using it as the kind of the core point for the criminal justice involved population to do more outreach, be more flexible, not have an office visit in 3 weeks, but be able to meet people more where they are as a way of doing that engagement. Thank you. That's very helpful. And everybody else, thank you.
And just my understanding is that Oregon did apply for an AOT federal grant. So keeping my fingers crossed.
Yeah, I think that we need a statutory change in order to give it a little bit of oomph so that it's not, please come to court, and if the person is, not doing anything, then we don't really have a lot of options. So we need a little bit of, I hope that we're looking at that in the next session next year. So fingers crossed.
Amy, I've got to run to my AOT court. So
Well, go enjoy.
Well, thank you. It was nice talking with everybody, and I got some ideas here, and I appreciate it, and thank you all very much.
We appreciate you sharing your experience. Betsy?
Everybody have a wonderful 3-day weekend.
You too, Judge Strelitz. Good to see you.
Bye-bye.
Before we lose some of the other judges, I just wanted to ask Judge Wiles if she's still with us, just to, I know Judge Wiles, you've been working with a couple of other judges around Ohio to develop some standardized forms around AOT. I was just curious, because we've heard from some judges who really like to develop their own forms, and other judges where I think having standardized forms would be really helpful. And I was just curious if you could give us a quick update on kind of where that project is and what you're hearing from some of your peers about their preferences, and maybe if any of the other judges have strong feelings on this one way or the other. I think that just would help us as we're working with other states who might be moving in that direction.
Thank you, Betsy. Yes, the committee developed forms that we would propose be standardized forms adopted by the Supreme Court in Ohio. Those were circulated to the judicial conference for comments before we were submitting them to the Supreme Court. Judicial conference came back with comments, and there were 1 or 2 changes that we made. And then my understanding is that those, Judge Park in Stark County was to send those up to the Supreme Court. I know they go through a couple committees before they're actually introduced to the justices. But my understanding is that those are out of our hands now, and with the Supreme Court going through the various committees.
I'm curious, have you heard from any of your peers? I know there are some judges around Ohio who have developed their own forms to kind of, because each program looks a little unique, and so it was, they like the idea of having some forms that they're able to modify. Are you getting any pushback from any of those judges?
No, because you can always adopt your own local form if you wish. And so I think the comments that we've received have been positive because, the judges, I think, would appreciate having standardized forms available to them. I mean, some of the judges who have created their own forms, it's out of necessity because there haven't been standardized forms. And if there's something in addition that they want to do, or something they want to do differently, they always have that ability to do that.
Oh, good. Okay. I guess I just assumed that they would have to use those forms if they were adopted by the Supreme Court, but it doesn't sound like that's the case. Okay, that's helpful.
I think the forms that we came up with are pretty standard as to what, all the counties that we looked at, the bigger counties, they're all pretty much what everybody's using currently.
Terrific.
There's not a whole lot of variation that we've noticed.
Good. Okay. Well, we'll be really anxious to see those once they're finalized so we can share them with other states who are looking to do something similar.
Drafting standardized forms is very challenging.
Yes.
Just because I did draft what I'm calling informal standardized forms because, well, nature abhors a vacuum. And if I'm still trying to sell this on other judges, the more tools I can give them to do things. Plus, the forms that were being used were traditionally state hospital forms, and they didn't exactly comply with Georgia's law. So, I mean, it's a lot harder than a lot of credit to Judge Wills and others, because it's a lot harder than you'd think when you start saying, well, what about this scenario? And what about this scenario? And anyway, but we're moving there. I don't think we're going to ask the Supreme Court to adopt my forms anytime soon, to be honest with you. And the Department of Behavioral Health has their own set of forms, but they're not, technically speaking, you're not allowed to use those for outpatient treatment. I didn't know if you knew that, Brooke, or not, but the DBHDD forms are technically only for inpatient and hospitals receiving funding to act as state inpatient hospitals.
Well, I'm guessing that might have been confusing to.
Well, you know, if I have an outpatient provider that doesn't have any forms, and I tell them use the state forms anyway. Let's at least we have to have some basic due process procedures put in place one way or another, and at least it gets us there, and then we can talk about what is the actual standard, that kind of thing. I've said too much today. Y'all have a nice day.
It's always nice hearing from you, Judge D'Antonio.
Absolutely. All right. Well, thank you, everybody. We really appreciate you logging in and joining us for this hour and 20 minutes. We look forward to the next Judges Chat, and I'm sorry, I don't know when that will be, but it'll be sometime this fall, I would guess. So have a great long weekend.